Hey, what's up guys, Aaron here. So in this video, I'm going to go over the objections that are coming in for the Celsius Chapter 11 plan. So taking a look at the computer, I'm going to go through a couple of the ones that came in through the docket, talking all about the different people, the different entities, including the U.S. trustee, as we'll see right here, what they have to say regarding this plan. I'm also going to touch on the fact that Michael Arrington is out of the NewCo board, and he actually made a Twitter post yesterday about why he left, or a little bit about why he left the board of directors. So let me just start here, read this to you guys, let you know what I think about this and who he left out right here when he warmly welcomes people as observers. So he starts out saying that a court filing was made talking about the amended plan, which is right here, showing a change in the board of directors for the new company. I will no longer be on the board of directors. Instead, Ravi Kaza, my partner at Fahrenheit, will take the seat. Ravi is an investor and advisor to Arrington Capital. So it's not like, Arrington Capital is completely leaving the board of directors. Not at all. I, meaning Michael Arrington, am not able to go into much detail on why I requested this change, but that info will come out in due time. This statement, meaning the one that I'm reading to you, was heavily edited by attorneys. I disagree with some of the decisions made around board constitution and in particular the board observers. So there were 3 people that were added to the board observers. We have Joe Lair, we have Brett Perry, and we have Simon Dixon. But here he says, I warmly welcome Joe and Brett as board observers. From what I've seen, they will represent the creditors, shareholders loyally. So what he's not saying speaks very, very loudly, leaving out Simon Dixon, and again saying that these 2 will represent the creditors and shareholders loyally, which is inferring that Simon will not. Now, I don't know Michael Arrington. I've never met the guy. I don't know his character. I don't know anything about him. So I am not going to speak on things I don't know about. But it's just a little bit of drama going into this confirmation process. So we can see the board of directors is the same, except again, Michael Arrington is out and Ravi Kaza, who is very, very qualified, is going to be in. So let's start out by going over the objections to the plan. So we have a long way to go before this is completely confirmed, as I'll explain to you in this video. So first we have the SEC objecting to the plan. So their big issues are, 1, Coinbase is being looked at as a distribution agent. Now, Coinbase has been in litigation with the SEC. So naturally, the SEC is not super pumped that Coinbase may be the company that's going to be giving crypto back to everybody. And they also have an issue with Cell Token about whether or not Cell Token is or is not a security. Now, I'm going to move through these objections quickly. This is just the summary of that objection. Next, we have an objection from Pharos Fund, something that I had not heard about until today. Basically, what's happening is Pharos holds approximately $82 million in claims, which makes up 94% of the claims in that class, which is going to be Class 8. Now, Pharos holding 94% of the claims in this class can make the plan unconfirmable. Their first objection is that the debtors did not demonstrate that Pharos would receive at least as much under the plan as it would in Chapter 7 liquidation. They, meaning Celsius, has provided no evidence demonstrating that the value of the shares in the NewCo exceed the value of the assets that would be distributed in a Chapter 7 liquidation. And they say that the debtors, meaning Celsius's analysis, appears to assign far greater value to assets in the orderly wind down versus a Chapter 7. Here they talk about how they value different assets under Chapter 7, under the NewCo, and also the orderly wind down. So here they say, taken together, these artificial adjustments total over $390 million. So there's a huge discrepancy again. And they're giving reasons why this plan should be turned down, especially that Series B preferred will receive just 0.1% on account of their interests. So they are trying to get the court to deny the confirmation of this plan. So this next one is from Harrison. He is a pro se creditor, meaning someone just like yourself. And this one got really, really into the weeds, and I'm not going to try to summarize it here, but it has to do with the alternative dispute resolutions, also known as the ADR procedures. So This really talks about clawbacks. So he has clawback exposure. I'm not going to go through everything here, but he really breaks down why there needs to be some changes to the plan in order for this to be fair, and talking about how the debtors and the defendants do not have access to the same information. So again, not going to cover this entire one. A lot of you guys were really surprised and messaged me regarding your preference exposure, because inside the ballot, it showed how much preference exposure you had. And people were messaging me. A lot of people are being like, I had no idea I had over $100,000 in preference exposure. And I told you guys to join the Telegram group and get involved and learn about it there. Because if you have over 100 grand, you are basically in the crosshairs of getting sued. So I won't talk too much more about that in this video. I've made whole videos about that. There's a link below to the Telegram groups. There's 2 for clawback defenses, if that applies to you. So next we have Otis talking about Cell Token. So he has been fighting for Cell Token for a very, very long time. Got to give it to him. This guy is a fighter, and he is displaying proof as to why he and a lot of other people believe that the Cell short squeeze was basically a fight against FTX, and also say that Cell Token should be 81 cents. And if it's not 81 cents, he wants the UCC and the debtors to produce discovery for all the documents related to Cell Token and everything having to do with FTX and Cell Token. Next, we have a law firm representing Koala 2, and this is one of the LLCs of Alex Mashinsky. And Koala 2 is objecting to the plan. Now, why are they objecting to the plan? Well, it has to do with equitable subordinated claims. Right now, K2, which is what they're calling this LLC, because it's Koala 2, they intend to challenge the fact that the claims for K2 will be subordinated, meaning they will not get their money. The lawyers for K2, again, this is Alex's company, say that the debtors have not shown and can't show that K2 is controlled by or ever was controlled by a former director, officer, or employee of the debtors. Or they say that it was engaged in inequitable conduct resulting in injury to debtors' creditors or conferring unfair advantage on K2. Now, I am not a lawyer, but I can't imagine them not tying this back to Alex Mashinsky. But maybe I'm wrong. I'm not a lawyer. This is not my job, and I'm definitely not getting paid enough to pretend like I'm a lawyer here. So we will see what happens with that. But basically, Alex wants to get the money from his LLCs. Next, we have a pro se creditor, Victor, who has been very, very active for over a year and a half, or I should say when this started, talking about his objection to the plan. He is talking about the Employee Incentive Plan, also known as the EIP, the metrics to get a bonus, basically. So there are people, employees at the company, insiders, some people would call them, that are going to get a bonus when they hit required metrics. And he is saying that the metrics are the bare minimum that these employees should be doing and are so vaguely described that they are easily abusable. So basically, these employees should not be getting paid extra to do things that are already in their job description, including a bonus for mining executives just for, as he calls it, energizing the mining assets. He says it makes no sense to set the bar so low. Also, Chris Ferraro, the CEO, basically he is going to get a bonus for not losing any more cryptocurrency. He says, how can you receive a bonus just for having the coins you need to return to your customers? Victor says another proposed bonus for Ferraro, the CEO, has a threshold performance that requires confirmation between November 1st and the end of the year. He says the CEO getting his company out of bankruptcy is just doing his job, which I do agree with. So he also disagrees with the third-party releases and the exculpation provisions. So next we have a really well laid out dispute here from someone named David Schneider, who is a pro se creditor, meaning he is someone just like yourself. Now, what he lays out is pretty impressive, and he's basically saying that this plan, if it is approved, goes against his constitutional rights in the 1st, 5th, 13th, and 14th Amendments, and he breaks it down one by one. And I found this actually very interesting to read. He says that the plan attempts to pay out Schneider, or I guess all of us, a portion of his claim by granting him an equity interest in the new company, right? Schneider does not want to be an equity interest in the NewCo, but there is no way to opt out, becoming a venture capitalist and or an investor. He says he is unwilling and does not consent to becoming an investor for a very high-risk startup venture. And he says that he is being forced to become an investor and that there is no just cause to force him to become an investor in this proposed venture startup. Very interestingly, he says the plan forcing conversion of a crypto liability owed to him into equity is effectively, get this guys, an unlawful and unconstitutional taking of property from Schneider, for he does not consent to this conversion. Now, I don't know if any of this will hold up in court. I am in no way a constitutional lawyer or scholar. I am anything but I found this interesting to read, and he has some balls for putting this out there. He says investing in this NewCo violates his fundamental right to liberty and infringes upon his fundamental rights to property, freedom of association, freedom of choice, due process, and equal protection under the law. And basically, he says that the plan needs to give creditors the election to opt out of this forced investment scheme, which causes them to become VCs and investors through forcing a conversion of their due crypto for equity. He talks about how this plan is being crammed down, and if the plan was actually really good, there wouldn't need to be any coercion to get this plan approved. The plan is a continuation of Celsius attempting to use creditor money for self-gain and self-dealing and does not have the best interest of creditors in mind. He goes on to say that this NewCo equity is speculative and unproven, having never been tested by any trading markets. So he says that the actual recovery could be way, way less and possibly less value than creditors would have received under a Chapter 7 liquidation. He says this new startup could end up in another bankruptcy, which I don't think that's impossible, so he may have a point there. And he says that the debtor can't force a creditor to accept an equity interest in lieu of cash payment without the creditor's consent. Again, I don't know how much of this or any of this would actually hold up, but basically, good job. I'm actually really impressed that you wrote this, just because he's voicing a lot of things that a lot of people are feeling, and a lot of people have been telling me, and I've been reading in the comments for months and months. So whether or not this holds up in court or this goes anywhere, I respect you, David, for writing this. And finally, we have the U.S. trustee. So the U.S. trustee has been in this case since day one. William K. Harrington. This name should be familiar if you've been following this for any length of time. He says the plan continues to include releases and exculpation provisions that are overbroad. The U.S. trustee has communicated these additional concerns to the debtor's counsel. So basically, he is reserving his right to amend or supplement this objection at any time. So what the U.S. trustee is saying is that the exculpation and releases are too broad, basically saying that we are forced to release too many people. Everybody is getting basically a release here. And what he's saying is that there may be some people that did do things that deem prosecution against them, possibly illegal or not. But that's what he's saying here. Too many people are getting too many releases where the creditors, if this plan is passed, cannot go after these people. All right, guys, that is it for the video. Thanks for watching. Lots of drama. This drama will probably continue for a while. I just hope that we get out of Chapter 11 as soon as possible. I'm tired of more money going towards more lawyers and more, advisors and all that, and I think we all are. All right, guys, I'll end the video there. Thanks for watching. Until next time, talk with you soon, and bye for now.